We propose
Let us proceed.
we propose to begin with the application for mandatory bail.
This is we call the I don't know. We call
It's number what?
399.
39.
399.
Yes.
It's the one.
It's the one for mandatory bail. And Counsel Frederick Panga will open the arguments and we'll take it from there.
If it may please court, my lord. Frederick Panga, my lord. Criminal business application number 399. It's an application for a single order. You have the applicants, 399/2025. It is for a single order to admit the applicants. I'm a retired Dr. Kizza Besigye, and I advocate retaliate mandatory bail. So that they are released from custody where they have been on remand since the 20th of November 2024. My lord, for brevity, the laws since November, 20th November 2024. My lord, the provisions of the law under which the application is brought are stated in the notice of motion. But the thrust is in Article 23, sub-Article 6, paragraph C of the Constitution of the Republic of Uganda. My lord, that application is supported by the affidavits of the applicants, and in response, when we joined the affidavits in response of the state, the applicants swore and were filed affidavits in rejoinder. Our colleagues, the state, were served with the affidavits, with the notice of motion, the affidavit in support, and the affidavits in reform. I wrote the uncontested facts that the applicants were arrested on the 16th of November 2024 in Nairobi. They are not contested. Reading the affidavits, those facts, the applicants were arrested on the 16th of November 2024 in Nairobi, Kenya. November 2024. They were produced and arraigned in the General Court Martial in Machinde. On the 20th of November 2024. On the 20th November 2024, my lord. You were charged with various offenses. Including offenses relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap 330. I know they were charged with various offenses, some under the Firearms Act, but the one which is pertinent is offenses relating to security, contrary to section 128, section 1, paragraph F of the UPDF Act, Cap 330. I know we state that offense because the penalty for the said offense, if found guilty, is that the accused person suffers death.
Are you saying somehow the charge in this application is under the UPDF Act?
I know there was a transfer.
Offense.
There was a transfer of proceedings to the magistrate court. So the
What is the current?
current one,
Yes.
following the transfer now,
Yes.
the charges were transferred from the General Court Martial to the civilian courts. At the Chief Magistrate's Court of Macau. And on the 21st of February 2025, the applicants were charged under Macau criminal case number 8 of 2025. For the offenses of treason,
This number?
8 of 2025. Uganda versus Colonel retired Dr. Kizza Besigye and Haji Obey retired. The captain, same process. My lord, the law is very clear. Article 23(6)(c) of the Constitution. That where a person is arrested in a criminal offense, tried only by the High Court, and who has been remanded in custody, or is on remand in custody, for 180 days before they are committed to the High Court. My lord, just for 6C, that where a person is arrested related for a criminal offense, in a case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such conditions as the court considers reasonable. My lord, in this case, we have stated that the 180 days accrued on the 19th of May and unlike what is stated in the affidavit in response, the applicants were committed to to the High Court for trial on the 29th of May 2025 and not the 26th of May 2025. But even though it was the 26th, which it is not, it was still the 188 days, 8 days after the expiry of the constitutional deadline. My Lord, that provision your learned brother, as he was then, the Honorable Mr. Justice Lamek Pasa, found that when the threshold of the 180 days has been met, the one in Article 23(6)(c), the 180 days has been met, the court has no discretion but rather has an obligation to release on bail. Its discretion only lies in determining the conditions of the release. And my Lord, in that matter, the state raised the point that at the time that application was heard for mandatory bail, there had been a committal. My Lord, that case is the scenario is similar to the one before your Lordship. That the accused, or the applicants for that matter, were in fact committed in the absence of their counsel on the 29th of May, 2025, 10 days after the 180 days had elapsed. The state in this case tried to argue that the application had been overtaken by events because there was a committal subsequent to the expiry of the 180 days. And my Lord, that is the position in the affidavit in reply, where the state, the deponent contends that this application is overtaken by events because of the committal on the 29th of May, 2025. My Lord, your learned brother Justice Lamek, as then was, found that the subsequent committal had no bearing on the application. Because by the time of the committal, the 180 days had accrued. So the constitutional deadline of 180 days had already materialized. So that the right of the applicant to mandatory bail had already arisen. The relevant part of the ruling, my Lord, reads that in the Eastern case, the applicant was charged on the 27th of June, 2011. By the time was committed to the High Court, I don't know whether I've lost you, so that. Yes, say that. Yes. So my lord, the court said that by the time I was committed to the High Court, the applicant had been on remand for more than 180 days. He was therefore already entitled to the constitutional right to bail, the only restriction being on such conditions as the court considered reasonable. And the court found that even in those circumstances, because of the mandatory right to bail, the exceptional circumstances for grant of bail did not arise. So we contend that even in this case, once the 180 days are ruled, it is not open to the state to require court to ask for exceptional circumstances. My lord, again, in that decision, your learned brother, as his name was, the Honorable Mr. Justice Karua, in the case of Joseph Luce versus Uganda, 1997, Volume 3, Kampala Law Reports at page 58. Again, in that case, my lord, the state opposed the right to mandatory bail by arguing that the applicant had subsequently been committed for trial and therefore he could not be released from bail. The committal having happened after the constitutional deadline. My lord, the court found that even though there had been a committal, provided he had been on remand for more than 360 days, and in brackets now 180 days, it was corrected, such person shall be released on bail. My lord, to settle the argument that there has been a subsequent committal, the Honorable Justice Lamin Mukasa stated that an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued under the provisions of Article 23(6)(c) of the Constitution shall not automatically cease upon committal to the High Court. Shall not automatically cease upon committal. So, my lord, the fact that there was a committal, to the extent that it took place after 180 days, it did not in any way remove the right of the applicants to apply for bail. My lord, that position has been carried in the more recent decision. My lord, it is criminal witness application number 21 of 2025. Besigye Stephen versus Uganda. Besigye Stephen versus Uganda. Sorry, my lord. In that case, the Honorable Lady Justice Grace Flavia Lamuno my lord, the court in that case took a proactive approach in light of the rights of the applicant in that case, Mr. Besigye. And found that where in line with Article 23(6)(c) where in line with Article 23(6)(c) and Guideline 10(1) of the bail guidelines, a person charged with an offense tried only by the High Court who was being on remand for 180 days or more without committal must be released on bail. In that case, the court has no discretion to deny bail. My lord, the court took the view, which we align with, that to continue to hold such person in detention beyond this period without them having been committed is inconsistent and contrary to the constitutional guarantee of mandatory bail. Lord, the court taking a view that mandatory bail is guaranteed to an accused person by the Constitution, not the state, and most respectfully, not the court. It is the Constitution which guarantees this right to an accused person. And my lord, in that case, the proactive position taken by the court is that the applicant need not apply. Once the court, on its own calculation, finds that there has been a breach of the constitutional deadline, it must release that person on bail. My lord, again, in KAIJA Robert versus Uganda, miscellaneous application number 29 of 2024. Your learned brother, the Honorable Mr. Justice Isaac Muat, found that the article and the guideline make it mandatory to release such a person on bail. The court only determines the conditions it considers reasonable for the release. But in the decision of Besigye, the court, over and above emphasizing the right of the applicant in that case to mandatory bail once the 180-day threshold has been met, cast a duty on the state in the event it is opposing bail. And my lord, the reason is that when the threshold is met, the Constitution affords the applicant a guarantee, so that if that guarantee is to be removed, it cannot be made or cannot be withheld on mere assertions. The court pronounced itself as follows: that the law places a burden on the state. The law places a burden on the state to provide compelling reasons to deny bail. To provide compelling reasons to deny bail once the constitutional threshold for mandatory bail is met. There is a duty on the state to provide compelling reasons why court should deny bail once the constitutional threshold for mandatory bail has been met. The court stated further, my lord, that mere assertions by the prosecution without evidence are insufficient to deny bail. Mere assertions are insufficient to deny the applicant's mandatory bail. The assertions must be proved. The assertions must be proved. Otherwise, there remain arguments which are merely speculative. There remain arguments that are merely speculative and which are not sufficient to override the applicant's entitlement to mandatory bail. The emphasis, my lord, we are making is that this is not ordinary bail, and that's why it's mandatory bail. It is a benefit or a right or a guarantee of the Constitution which accrues and is available for the benefit of an applicant once the 180 days accrue. So much so that there is a duty on the state, the burden shifts, to show with cogent evidence why that benefit should not be enjoyed by the applicant. My lord, that position again is stated in the case of Karua Hassan versus Uganda, criminal misdemeanor application number 204 of 2023. It is also reiterated by learned brother, your are only speculative and cannot remove the right which is guaranteed by the Constitution, which has matured, has been the case in the matter before us. The first objection was that the applicants are not law-abiding. Because the charges against them emanate from participation and lawful act, where they took place, when they took place, or the level of participation of the applicants. My lord, it is such statement which learned brother warned the court, mere assertions which are speculative and which fall far, far short of removing the entitlement of the and again, my Lord, in the Kizza Besigye reference 20 of 2005, the Constitutional Court pronounced itself that the constitutional dispensation in Uganda is that an accused person is presumed innocent until they are proven guilty. So in a scenario where the court has not pronounced itself on the activities and whether they are unlawful, it is not safe for the court to take that as a valid objection. My Lord, again in Kavuma Hassan versus Uganda, Supra, which we referred to, it was exactly the same objection. Unlawful activities. The learned brother, the Honorable Justice Mwaka, found that that statement was a mere assertion which had to be disregarded. And that was a case where Mr. Kavuma had 8 charges of aggravated robbery. The court disregarded those statements. Now, the second objection by the state is in paragraph 5 of the affidavit in response. Sorry, I beg your pardon, paragraph 15 of the affidavit in response. The objections are the same for the trial, where the state says that the accused persons have not spent 180 days on remand. The state, however, admits that they have spent only 168 days. And my Lord, they base the calculation the state contends that there are 168. 68. 168. We calculate from 21st February 2025 up to today, perhaps. And what we have submitted the case of Mwesi, where your land brother, in curing the lacuna caused by the Honorable Kabaziguruka petition, they appealed that petition for charges which stem from the General Court Martial. and also referring to the Aaron Kizza application, that the court must intervene where there is such a lacuna. But it's not the making of the applicants, that the state pursued a course of action that was deemed unconstitutional by the Supreme Court. The applicants are merely victims of that unconstitutional order. So that the Supreme Court made a pronouncement the state wants to argue that those days when they were on remand should be brushed aside. That is wrong. And those points were covered by the Honorable Justice Mwata, page 3 to 5 of his ruling. Say that in matters of that nature, the court must invoke its inherent power to grant the accused bail. And that matters of bail applications in those cases must be, the proper court before they should be brought is the High Court. And I know the court was emphatic and grounded its decision of views in Article 126(2)(e) of the Constitution, that it administers justice without undue regard to technicalities. So, my lord, the lacuna caused by the pronouncement of the Supreme Court which impacted on the charges before the General Court Martial and the remand there, cannot be visited against the rights of the applicants. As victims of the process, they are entitled to take benefit. That is where the court comes in. Because it is the custodian of justice. My lord, criminal prosecution are such that all the resources of the state focus on an individual. In this case, the two individuals before your lordship. So that any breaches of the law of the state cannot be the fault of the applicant. And the state cannot be allowed to take benefit at the expense of the applicant. That was the view of Ivan Brother. And my lord, we are mindful of the fact that in this case there was a transfer. And that transfer is admitted in the affidavit of reply. But it would be absurd for the state to argue that it took over everything about the prosecution except their remand. That is absurd. So who remanded them? they were in a government facility. And my lord, DIP Ukundako accepts my lord, in their affidavit, I just want to emphasize that. My lord, in paragraph in paragraph 11 in particular, so my lord, paragraph 10, if I may read it. The first applicant, and in his evidence, he does state for himself and on behalf of the second applicant that on the 31st of January 2025, the Supreme Court of Uganda delivered judgment in the Constitutional Appeal number 2 of 2021, Attorney General versus Economic Kawazuka, inter alia, that all trial of civilians before the General Court Martial was unconstitutional. In paragraph 11, that because of the Supreme Court judgment, we were not produced before the General Court Martial on the 3rd of February and were remanded in prison without any lawful remand warrants or charges. And my lord, in response, which is in paragraph 10 of the affidavit of Ukunda, that is an affidavit in reply to the first applicant's affidavit. He says in paragraph 10, in paragraph 9, the contents of paragraph 6, 8, 9, and 11, my lord, 11, which speaks to their being remanded without lawful warrants in the government prison. Mr. Kundakwe says that the contents in the applicant's affidavit are admitted to the extent of the charges against the first applicant, his appearance before the General Court Martial, his appearance before the General Court Martial, and remand to prison. So he's admitting that they will remand. That position is also the same in his response to the affidavit of the second applicant. And in regard to the second applicant, Mr. Kukundakwe avers in paragraph 7, he admits the charges against the applicant, his appearance in the court martial, and his remand. So, my lord, to the extent that the depot admits that they were on remand, and they stayed on remand, the court should cure the lacuna. And my lord, you should be mindful of the fact that there has been no break whatsoever from the events that unfolded in the General Court Martial. It has been a continuous process of remand after remand after remand, with not a second of liberty in between. So we invite the court to invoke its powers in Article 126(2), Rising Justice, 139(1) of the Constitution, Section 17 of the Judicature Act, to cure that lacuna, to prevent an abuse of process. It cannot be this court to argue that the remand between November 2024 and February 2025 was no remand. So the court cannot aid the state to commit wrong. We repeat, it's the same state under the veil of the General Court Martial, which manifested in the Karua Magistrates Court. The consistency is the remand, and perhaps the applicants. My Lord, be that the case, in the alternative and without prejudice to what we have said, in the unlikely event that the court should agree with the state that the 180 days should start from the charges at Nakao, my Lord will say unlikely, because the court cannot ignore the fact that the applicants have been in custody since November. My Lord, the fallback position is found in the judgment of the court, of the Constitutional Court, in what we call the Kizza Besigye reference, number 20 of 2005. Number 20 of 2005, Uganda, PPP versus Kano retired Dr. Kizza Besigye. My Lord, in that decision, and which was reaffirmed in the constitutional petition number 20 of 2006, the court found that still under Article 23(6)(c), 23(6)(c), an accused person triable only by the High Court, triable by offense, charged with offenses triable only by the High Court, and who has not spent 180 days on remand can seek release on bail. And in that case, the court has the discretion to grant or not to grant bail if they fail to show exceptional circumstances. My Lord, the court found that that is the import, that is the only reason, that is one of the reasons, I beg your pardon, why there was amendment number, why there is the Trial on Indictment Amendment Act, number 9 of 1998. My Lord, that is the rationale for the Trial on Indictment Amendments Act number 9 of 1998. My My lord, the court argued that in such a case, where the applicant comes to court through this article, the court does not consider the conditions for ordinary bail. It only refuses to grant bail the discretion if the accused or the applicant fails to show or satisfy court about or regarding exceptional circumstances. And my lord, for brevity, one of the exceptional circumstances is age or advanced age. My lord, in the affidavit in reply of Ukundakwe, BIP, both in regard to the first applicant and the second applicant, he admits that both applicants are of advanced age. My lord, as we cross, as I cross, sorry, not we, I cross, because my colleague may want to add. The other objection has been in paragraph 20 and 22, that the accused will abscond from bail. Such plain statement was the case in the constitutional reference 20-205 and the Businje Stephen case. Again, it was a statement that the accused would abscond because of the gravity of the offenses. My lord, the court in that case found that that too was a plain statement, perhaps because the state was not expected to say anything else. My lord, we are mindful of the fact and has been shown in group annexure F of the first applicant's affidavit support. He has been charged several treason, misprision of treason, terrorism, rape, etc., and has not failed to meet any condition, because in all those cases have been used. My lord, in paragraph 23 of the affidavit in reply, because they are more or less the same. DIP Kukundane states that in the treason trial against the first applicant in 2016, he absconded. I don't take it that abscond must be a finding of court in order to show that there was an abscondment. But my lord, as shown in the affidavit rejoinder, that is not true. His sureties were never penalized, and in fact those charges were withdrawn. My Lord, the interesting aspect that in that allegation or statement, the state supports that with an ICMIS record. My Lord, to the extent that we are alive, we know that ICMIS was not there in 2017. So where the state is getting these things, we don't know. But that is the state. My Lord, there is an objection in paragraph 26 regarding the sureties. My colleagues will allude to that to save time. That your learned sister, the Honorable Justice Kania, in application 133 of 2025, found all the sureties substantial. My colleagues will submit that. And they are the same individuals. The state has not shown that there is any change regarding those sureties. But the other objection is in paragraph 27, which speaks to investigations. We are aware that there has been a committal so that investigations are placed. There are no investigations interfering. The other objection is in paragraph 28 and 29 regarding witnesses in Uganda, Kenya, Switzerland, and Greece. And that the applicants have associates in these countries. It is the same unsubstantiated allegation which the court in Lucinda Stephen said should be disregarded. The associates are not left. And in the indictment, there was nothing to show that there was evidence from these countries. But in paragraph 30, the state contends that the followers of the applicants are violent. They threaten the court, they sing loudly, they hold press conferences, etc. The benefit we have today is that, my Lord, you are present. We didn't hear any hymns or songs for that matter. And we don't want to take the view that your Lordship was scared or under attack. So, my Lord, we submit that the applicants have satisfied the requirement to be entitled. Lastly, my Lord, as I wind up my submission, as indeed the Constitution commands, this application was made in the lower court because the lower court is enjoined. And the power of the lower courts to do so have been the subject of court's findings by your learned brother, as he then was, the Honorable Mr. Justice FMS Bonatendo in Uganda versus Tesimana Rosemary. Massacre Criminal Revision 13 of 1999. Uganda versus Tesimana Rosemary. Criminal Revisional Cause Massacre, number 13 of 1999. Criminal Revisional Cause, number 13 of 1999. And again, the Honorable Mr. Justice FMS Egonantende, and then was in Criminal Revisional Cause Massacre, number 5 of 1999. That one is Shabukuria Matia versus Uganda. My Lord, the court, the High Court, informed the lower court that it had power to intervene in delays of this nature to avert a miscarriage of justice. What we have seen, my Lord, is that the lower courts have been shy or meek or timid to do the right thing. So, my Lord, it is a breath of fresh air that we are before a high court, which we believe will not be shy, will not be timid, and will not act under any influence, as the learned brothers found in the Tumwesi jail matter. We invite court, my Lord, to invoke the bold spirit and not be timorous. So that an abuse of process and a miscarriage of justice is averted. My Lord, I'm closing. I just want to make a final remark. My Lord, we refer, my Lord, to a land author, Lord Alfred Thompson Denny, in his publication, The Discipline of Law, London, 1979, at page 315. My Lord, if I may quote as I conclude my remarks. Say that if the powerful still abuse their powers without restraint, if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. It is thanks to the dominant influence of timorous souls. Semicolon. Bold spirits will not let that stand. And bold spirits will not let any rule of law Holy Spirit will not let stand any rule of law which impairs the doing of justice. They will do all they legitimately can do to avoid that rule. Even change it so as to do justice in the instant case before them. My Lord, it's our prayer, as my colleagues come, that the court will adopt, unlike the courts below, a bold spirit so that justice is done in the matter before us. My Lord, my colleagues have some questions.
May it please you, my Lord, I intend to address you in two specific areas, or rather issues. The first one is about the spirit of mandatory bail. The spirit of Article 26, rather Article 23, sub-Article 26, paragraph C. My Lord, I will make reference to a number of authorities that have brought out Article 23, 23.6, being the spirit, my Lord, being protection and safeguard the sanctity of the right to liberty, as well as guarding against abuse of the court process. My Lord, I will refer you to the decision of Besigye Stephen, miscellaneous application number 021 of 2025. It's a very recent one. My Lord, th July to be exact, by Justice Flavia, 30th July 2025. And my Lord, on page 4 of that decision, your sister had this to say: bail under Article 23(6)(c) of the Constitution was introduced as a safeguard to prevent the state from keeping accused persons in prison indefinitely without trial, particularly where the committal process has been delayed. The court is therefore required to strike a balance between the applicant's right to liberty and presumption of innocence and the public interest in ensuring that those charged in criminal offences are brought to justice. And she concluded by saying, in doing so, the court should impose conditions that are fair, reasonable, allowing the accused to enjoy the benefit of mandatory bail, while also making it possible to ensure that the accused continues to attend court as required and to be traced. So the point here, my Lord, is that the right to bail under Article 23 was meant to guarantee enjoyment of the right to liberty and also safeguard the processes of this honorable court. The same decision is reflected, my Lord, or rather reinforced in the authority of Kato Henry. We have our bundle of authorities, my lord. Kato Henry is criminal miscellaneous application number 096 of 2025. My lord, in this decision,
I know we don't have those bundles necessarily to file. You say you have some.
my lord, they are on ICMIS, but for the benefit of the state, I can offer them a copy. But they are there on the ICMIS. My lord, this is a reinforcement of the earlier decision cited by my friend here, Mpanga, the one of Justice Muat. Now, this one, my lord, is about, again, Article 23, where His Lordship said, after reviewing the affidavit evidence and the applicant's submission, this court finds that the applicant was detained on remand for over 6 months without committal to the High Court for trial, exceeding the mandatory procedure timeline. The subsequent committal occurring only after this period lapsed must be weighed in the applicant's favor, particularly in the context of any relief sought as bail to prevent further prejudice. The emphasis, my lord, here is that notwithstanding the fact that one has been committed to the High Court subsequent to the expiry of the mandatory period of 180 days, is not a preclusion or a bar to being admitted to bail. My lord, the case of Besigye Enoch, which is also on record there, Besigye Enoch, my lord, on page 4 of that decision, it is criminal miscellaneous application number 133 of 2025. Which my learned friend Mpanga made reference to, but mine specifically is about the spirit of Article 23. On page 4, Justice Muata had this to say. He was quoting with approval the ratio disdendi in Sabuharia Matia versus Uganda, which is cited there on page 4. He said, the court emphasized that the High Court must protect its ability to function as a forum of justice and not an agent of oppression, particularly in cases where a prolonged detention. The court emphasized that the High Court must protect its liberty my lord, if I may read again, the court emphasized that the High Court must protect its ability to function as a forum of justice and not as an agent of oppression, particularly in cases where prolonged detention without trial continues or constitutes an abuse of court process. My lord, in this particular case, the accused persons have been on remand as of today, have been on remand for 263 days. As of today, they have been at Iruzira, maximum prison, which is a remand prison. Luzira maximum prison, which is a remand prison, for 263 days. My Lord, I will refer you again to the decision of Colonel Dr. Kizza Besigye. This is Colonel Besigye versus Uganda. It's bail application number 228 of 2005. (228 and 229, my Lord, of 2005. There were 2 bail applications. They are there in our bundle, my Lord. On page 6, Justice Ogola, the principal judge then, emphasized the role of court in protecting the right to liberty. And indeed, he explained the sanctity of this right in the following terms. I have taken into consideration the fundamental importance of bail as the judicial instrument for ensuring the liberty of the individual. In this regard, the quest for bail is a quest for liberty. The right to the liberty of the individual is next only to the individual's right to life itself. You need to underline that. The right to liberty of the individual is next only to the individual's right to life. After the right to life, the next one is right to liberty. In that hierarchy. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is so precious a commodity that during the American struggle for independence, some 300 years ago, one of the American independence protagonists, I believe it was Thomas Paine, summed up the situation with the following eloquent and immortal declaration. A declaration not of suicide and despair, but of defiance and triumph. That is quite instructive, my Lord. A declaration of not suicide and despair, but of defiance and triumph. Give me liberty or give me death. That sums it up all. These are not my words, justice of God. Liberty is the very essence of freedom and democracy. In our constitutional matrix here in Uganda, liberty looms large. The liberty of one is the liberty of all. The liberty of anyone must never be curtailed lightly, wantonly, or even worse, arbitrarily. Article 23, Clause 6, this is the provision we are emphasizing. Article 23, Clause 6 of the Constitution grants a person who is deprived of his or her liberty the right to apply the competent court of law for the grant of bail. I want to sum up what Justice Ogola said by reading the following line. The courts from which such a person seeks refuge and solace should be extremely wary of sending such a person away empty-handed, except, of course, for good cause. Ours are courts of justice. Ours is the duty and privilege to jealously and courageously guard and defend the rights of all, in spite of all. guard jealously the right of all in spite of all. My Lord, is a very, very instructive words from Justice Ogola, Principal Judge Emeritus. They sum up the significance and sanctity of the right to liberty, which is next to life. My Lord, it is the reason the framers of our Constitution made that right mandatory when one has spent 180 days on remand. That's the reason they made it mandatory. And my Lord, I want to emphasize the submission of my learned friend here, Mpanga. Initially, the constitutional order had provided for 360 days. Under the 1995 Constitution, it was 360 days. As a nation, we consider that to be irrational and inimical to enjoyment of the right to liberty which is granted by God. It informed the amendment of 2005 to reduce it to 180 days. And now, the state is advancing such flimsy reasons to derogate from that sacred provision of the Constitution. This court should not be used as a forum of oppression, as cited by Yolandi Bragg, Justice Moore. This is not a forum of oppression. My Lord, I will recite the last authority on that. Again, it is Dr. Kizza Besigye, constitutional reference, 2005, 2006. My Lord, on page 8 of that decision, the Constitutional Court unequivocally proclaimed on page 8 that we turn to Article 26, Clause 6, B and C. We accept the general position as stated by both the counsel that the court has no discretion to grant or not to grant bail after the accused has shown that he or she has been on remand in the custody for 60 days before trial or 180 days before committal to the High Court. As regards Article 23(6)(c), this is specific now in this particular case, where the accused person has been in custody for 180 days on an offense triable by High Court only and has not been committed to the High Court for trial, that person shall be released on bail on reasonable conditions. Like Article 23(6), the court has no discretion to refuse to grant bail to such a person. In both Article 26(6)(b) and C, the court has discretion to determine the conditions for bail. My Lord, this is binding on this honorable court. This is a constitutional court decision. I don't need to emphasize the point that it is binding. All I need to emphasize again, the right to bail, the sanctity of liberty, as it was explained in that decision on page 11, where the burden is cast on you to balance the two imperatives. There are two imperatives, and these are captured here. The needs of society to be protected from lawlessness and the considerations which flow from people being remanded in prison custody, which adversely affects their welfare and that of their families, and not least the effect on prison remand conditions if large numbers of unconvicted people are remanded in custody. My Lord, these are some of the imperatives. And finally, on page 12, this is what the Constitutional Court said. Remanding a person in custody is a judicial act, and as such, the court should summon its judicial mind to bear on the matter before depriving the applicant of their liberty. My Lord, I think those authorities are enough, but probably I also cite one of the FHRI, the last one now, because it was also cited by my friend here, Mr. Mpanga. I will go to page 36, still on the significance of this right to liberty. The institution of bail is meant to protect and guarantee the fundamental rights of the individual to liberty, the presumption of innocence and the due process of the law on the one hand, and the societal interests on the other. The most important condition is that the accused will return up for his trial and will not interfere in any way with evidence. My Lord, it's about, again, putting emphasis on the right to liberty. So I think there is no doubt that this right is one of those most sacrosanct rights guaranteed under the Constitution. Now, my Lord, with the authorities I have cited of the Superior Court, which are binding on this Honorable Court, but also those which we have cited, like the one of Justice Muata and Justice Lamun, granting mandatory bail even after committal, are equally binding on this Honorable Court, my Lord. We would like to cite the the case of Semogerere and others versus the Attorney General, Constitutional Appeal number 1 of 2002, on the question of doctrinal precedent, where the Supreme Court, my Lord, stated that as regards, of course, they made reference to decisions of Superior Court being binding on lower courts. I don't need to waste your time on that, my Lord. But when talking about decisions of your brother and sister justices of the High Court, judges of the High Court, they said as regards its own decisions, the decisions of this court, it would normally be bound by them, except under the following circumstances. One, that the court is entitled and bound to decide which of the two conflicting decisions of its own it will follow. If there are two conflicting decisions, there you have the discretion to choose which one to follow. You may not necessarily be bound. But in this particular case, my Lord, the decisions are consistent. That even after remand, rather committal, mandatory bail still stands. So that first proviso is not applicable. The second proviso is that if court is satisfied that the decision was given by incuriam, it's our submission, my Lord, that going by the doctrine of stare decisis, the decisions we have cited are not by incuriam, because they formed the gist of the proclamations made by court in those particular decisions. I want to sum up this point of civil liberties, my Lord, by again speaking to the spirit of the practice guidelines My Lord, the practice guidelines on bail the Constitutional Bail Guidelines for Courts of Judicature, Practice Directions 2022. My Lord, particularly Regulation 10, which talks about mandatory bail for offences triable only by the High Court. Clause 2, or rather paragraph 2 of this Regulation 10, in the case of a person who has been on remand for 180 days in accordance with Article 23, Clause 6C of the Constitution, the Magistrates' Court shall immediately refer the file to the High Court. My Lord, I want to draw parallels with a sick person who requires an ambulance. If the file of Dr. Besigye and Obed Lutale before the magistrate in Nakawa who handled the pre-trial processes was a human being, if that file was a human being, on the 19th day of May, they would have put that person in an ambulance to the referral hospital. To the referral, because the regulation provides shall immediately, upon expiry of that 180 days, immediately forward the file. And in the same spirit, my Lord, Regulation 8, time for disposal of the bail application in the High Court. The court shall consider and dispose of an application for bail expeditiously, and in any case, within 30 days from receipt of the application. Said, one shall be determined expeditiously, but in any case, if court is constrained by some supervening factors, not exceeding 30 days, my Lord. All this is meant to emphasize the point that the law accords the right to liberty the sanctity it deserves. And it is the reason, my Lord, speaking to the spirit of the law, that under Section 76 of the MCA, Parliament directed the magistrate handling such a matter that once 180 days have lapsed, don't do anything else. The next course of action is consideration for mandatory bail. My Lord, for the accused person to continue being on remand up to the present, the 263 days, when all the laws we have cited, the Constitution, the Acts of Parliament, the practice guidelines, the authorities cited, all speak to the urgency of matters relating to the right to mandatory bail. In itself, my Lord, is a negation of that spirit. To see to it that they are still on remand. And as we speak, my Lord, no arrangements have been made for the trial. The state is not talking about the trial at all. And actually, for the record, my Lord, there is still a debate. Was the committee made to this division or to the ICT? That's where we are. Looking for a forum where the trial will be conducted from. To the prejudice and detriment of the applicants, and particularly the sanctity of their rights. My Lord, the last issue I wanted to speak about the argument that the charges before the Nakawa Magistrate Court are different from the charges that were preferred against the accused persons at Machindia General Court Martial. That's an absurdity, my lord. It would be a travesty of the IST order, my lord, if that argument was accepted by this honorable court. From the facts which are not disputed, as highlighted by Mr. Mpanga here, my learned friend, the state is the one that actually kidnapped, picked Dr. Besigye and Obed from Kenya on the 16th day of November. And it is the very state, Uganda, which preferred the charges against the Obed Rutale and Dr. Besigye, Uganda, in the General Court Martial. It's the same state, Uganda, that moved the then or the defunct General Court Martial to remand the accused persons in Brazil. When you look at the chain of events, my lord, after the intervention of the Supreme Court in the matter, because it's well documented, it is the same state that preferred those charges relating it to the same file before the General Court Martial. On the same set of facts which are before you. Same set of facts, same allegations. Even the particulars are all the same. Even the countries they are talking about, Switzerland, Greece, Kenya, no mention of anything different from what was before the General Court Martial. So to purport to treat those as separate charges, my lord, would be stretching this matter to levels of absurdity. So invite you, my lord, to dismiss that argument with the contempt it deserves. Finally, my lord, I've addressed you on the mischief that the Constituent Assembly attempted to curb, keeping people, accused persons on remand indefinitely. My lord, this honorable court shouldn't acquiesce in that, shouldn't be treated as an accomplice in the persecution of the applicants. We pray that you be pleased to admit them to mandatory bail. My lord, my colleagues will address you on the issue of the sureties, because yes, Mr. Mpanga has already cited the decision of your dear sister, your land sister, my lord, not dear sister. Your land sister, Justice Comfort, on the issue of the sureties, which has not been set aside or in any way overturned. My lord, we shall continue addressing you the same, because we have no sureties.
You say you want to present them or you want to adopt the
We are adopting those other ones, but making an addition. We do supplement.
To praise your lordship, Aaron Kizza, also counsel for the applicants, and I will continue and reiterate the earnest plea of the applicants that they be admitted to mandatory bail I'll add a few clarifications. One such clarification, Your Lordship, is to clarify the nature of arrest. That on 16th of November of 2024, what happened on 16th of November 2024, what happened in Nairobi, Kenya, to the applicants who were going for a book launch of Honorable Karua Martha was not a mere or ordinary arrest. It was an abduction. So before you, Your Lordship, are victims of abduction. That is contained in paragraph 5 of the affidavit of the first applicant in support of the mandatory bail application, paragraph 5. Your Lordship, before they were remanded and following their abduction from a foreign capital, they were subjected to incommunicado military detention. They were subjected to incommunicado military detention at the Machindi military barracks in Kampala, Uganda. That took for 4 days, 4 clear days. And you are in between 16th of November to 20th of November the same year, 2024. Before we go very far, this has legal implications because, first of all, incommunicado detention is unconstitutional and is a violation of personal liberty. That Article 23 seeks to protect. But even more poignantly, Your Lordship, according to our law and specifically the second schedule of the 2012 Prohibition and Prevention of Torture Act, Item 2, subparagraph 3, incommunicado detention is a form of mental or psychological torture. So, yet again, before you, Your Lordship, are 2 victims of psychological torture visited on them by Uganda People's Defense Forces. Of course, torture is a crime. And in this incident, the scene of crime is Machinde military barracks, Your Lordship. So after enduring torture and abduction, as I have adumbrated above, on the 20th of November 2024. The applicants before you were arraigned. They were arraigned before a kangaroo military tribunal. They were arraigned before a kangaroo military tribunal. That military tribunal was at Machinde. It is like 1 kilometer away from the scene of crime of incommunicado, torturous incommunicado detention. They have never been free since then, Your Lordship. They have never been free. And that's why they are coming before you. And those facts, I must emphasize, are not mine. They are contained in paragraphs 4 and 5. Signed sworn statement of the first applicant, paragraphs 4 and 5. Your Honor, the duty of releasing the applicants from on account of mandatory bail rests primarily the court.
My Lord, just a moment. I think this is just overwhelming court review.
Come again?
It's my colleague is simply overwhelming court review.
Most of that. So, before I was rudely interrupted, Your Lordship, by the cantankerous Richard Birivumbuka, I was developing a thought. The fact that even if the applicant has not applied, even if the applicant has actually not applied, that's not a prerequisite for mandatory bail. The application for mandatory bail is not a prerequisite for mandatory bail. The prerequisite for mandatory bail is the effluxion. The effluxion of 180 days for capital offenses. It's not an application. It behoves the judiciary, but specifically the trial magistrate, one, to count the days, to be aware of how many days the accused before that person has spent on remand, and as soon as they clock 180 days in the case of capital offenses, pursuant to section 76 that has already been alluded to of the Magistrates Court Act, the magistrate can simply release. It is as simple as that, although some people want to complicate it. Now, Your Lordship, if the magistrate does not want to release the applicant following the parent law, there is subsidiary law, or the bail guidelines. Because for me, there should be no debate between a conflict between parent law and subsidiary. But in case the magistrate has any doubt about what to do, they should follow regulations 10 of the bail guidance and immediately refer the file to the High Court. And once that file is referred, again in sub-regulation 11, the registrar of the High Court or the criminal court to which the matters are referred is obliged, is not requested, is obliged by the bail guidelines to schedule them and of course mindful that the court should resolve the matter within 30 days. The reason the magistrate is assumed to know the remand days because every remand, Your Lordship, happens under the remand warrant. Every remand happens under the remand warrant of a judicial officer and before committal specifically of a magistrate. Your Lordship, a magistrate cannot feign ignorance that somehow I did not know that the applicant before me, the accused before me, has not spent 180 days, because every mention they have to be aware of how many days that the accused person has spent on remand before further committing them on remand. Your Honor, it is the argument of the state that they are about chance. The reason they're objecting, one of the reasons they're objecting to the mandatory bail, which is an unconstitutional reason, of course, is chance, press conferences, and yes, chance and press conferences. I want to say that those are constitutionally protected rights under Article 29. And a thorough reading of Clause 1, Article 29, would preclude the state from citing it as a ground for objection. A related objection, Your Lordship, is that it is in paragraph 29, I think, of the reply, of the state's reply, and it says that that the accused is of a high profile. Paragraph 29 of the affidavit of Kukundakwe Kusinje. The reason is that the accused are high profile, influential, and command a big following. Your Lordship, few statements are astounding as this in the journey of a legal profession. So you are being invited on record in writing, Your Lordship, that you stop the bail, the liberty of the accused, simply because they are high profile, influential in society, and command a big following, and they have the audacity of including this in a sworn testimony and filing it on the record of the High Court. Your Lordship, high profile, popularity is not a ground for denial of liberty, even if it were not mandatory bail. I think it is irregular for the state to be envious of the accused. The point of liberty has been succinctly clarified, but one of the fundamental points of mandatory bail is actually to stop trial without detention. Detention without trial. And these are not my own words, Your Lordship. These are the words of the Constitution. And the Constitution adumbrates them in Article 43. The twin purpose is prevention of political persecution. Again, Article 43 succinctly and expressly outlines that. It is a factual reality that the accused are being politically persecuted. although it goes without saying, the accused have taken the trouble to outline it in paragraph 3, or rather paragraph 13, I beg your pardon, paragraph 13 of their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure. Your Lordship, I will end by clarifying the issue of mandatory bail, especially the fact that I want to clarify, one, there was a transfer of charges. This followed a Supreme Court decision. And unless the state is saying that it defied the Supreme Court decision and it did not transfer the charges, but of course, the facts would betray them. Your Lordship, what changed was only the courts. The fact of remand itself has never changed. Howsoever framed, the charges that were in the court martial are still here by order of the Constitutional Court. The idea is that the facts are the same, have not changed, and the law is on the principle of legality and double jeopardy. Does not allow, it's not even that the state can now introduce new facts. The law on the principle of legality and prohibition of double jeopardy, that's contained in Article 28 of the Constitution on fair hearing, does not allow twisting facts so that on the basis of the same fact you bring a multiple of charges, you keep tinkering with the legal nature of charges while you're using the same fact. That is not allowed, and in any event, it would have been prohibited by the order, express order of the Constitutional Court. So the accused or the applicants have been remanded by 4 courts. The first court to remand them was the Kangaroo Military Tribunal on 20th of November 2024. Following the Supreme Court judgment, the applicants made an application to the High Court Civil Division for habeas corpus. They came and they argued it, and on one of the questions they argued it, I was there, even though I was still, yes. So they were remanded by that court, even before their ruling on habeas corpus would be given. Then they were remanded by a magistrate's court in Nakawa, and then they were remanded by the criminal court, the criminal division here. That is just for clarity. Most obliged, I will yield the floor to my colleagues to address other issues.
My Lord, I will be so brief.
Said that avoid repetition.
Yes,
We are not keep rotating on the same grounds.
Yes, my Lord.
Kindly, I think, let us restrict on the point that has not been raised by another advocate. For the interest of time.
Much obliged, my Lord.
This is Council.
Luyimbazi Nalukola. My Lord, I will not consume a lot of time, but rather only 2 minutes. My Lord, you have a simple task today only to implement a constitutional commandment. Which is provided for under Article 23, Clause 6, C. My Lord, the provision is in respect of actual bail. Our application, my Lord, is not for a discretionary bail. And indeed, my Lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. But rather to receive a bail, my Lord. That provision was deliberate and intentional by the framers of the Constitution of 1995. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial, which was characterized, I beg your pardon, which characterized our political history, my Lord. My Lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and wishes the framers of the 1995 Constitution intended to achieve, my Lord. My Lord, I invite you, my Lord, to stand tall over the unsubstantiated allegations advanced by the state. To persuade you not to grant the application, my Lord. My Lord, I beg to rest.
My Lord, I have only one or two things to say. Firstly, to reject the proposition in the paragraph 17 of the Respondent's affidavit that the applicants have only spent 167 days. We just want to emphasize that there is only one state, and that is the state of Uganda. And
States they have been on the since that they have been in one for only
167 days. They deliberately refused to account for the period between 20th of November 2024 and 20th February 2025. They admit that period in their affidavit, but they refuse to account for it. And I've said there's only one state, and it is the state of Uganda that was holding them between that period, which is 90 days. So if you add 90 days to the admitted 167 days, that's a whooping 257. But if we count up to today, it's 263, as indicated by my colleague, Arias Ikwa. You have the final word. Count the dates from actually the date of arrest. The date of arrest or abduction in Kenya by Ugandan military in league with the Kenyan military. That matter is subject of a case in the courts of Kenya. The other point, you have been told that the applicant, the first applicant, has been in many cases. What the prosecution is saying, this is in paragraph 18. They even cite an existing case, which is case number 624 of 2023. Kindly note, my lord, they are not talking of convictions. They are talking of prosecutions they have mounted against him without securing a single conviction. Prosecutions designed to keep the first applicant in custody, just like in this case. You can only quote previous antecedents when a court has pronounced itself and there is a conviction. For the case that is pending before the Nakawa Court, 624 of 2023 criminal case, the prosecution cannot have their cake and eat it. Why have they not concluded the prosecution since 2023? You come to cite a case where again you are guilty of laches. The associates who are accused of singing are not named, nor are tapes of what he finds, the music that he finds not good, not so melodious to his ears. So it's a mere allegation. And what if others have sung? Are these two applicants going to be punished because others have sung? We are asking the court to ignore. Finally, I just want to remind the court that Article 126 of the Ugandan Constitution, which we happily borrowed from in Kenya, clearly states that the judicial authority comes from the people of Uganda. And it is to be exercised in accordance with the Constitution, which has been amply cited to you by my worthy colleagues who have elaborated on the law applicable in this case. The Constitution also clearly states that it is the supreme law of the land. So I'm most respectfully telling the court that it has no option but to grant bail on terms, such terms as are reasonable especially because the prosecution, as per the affidavits, have no compelling reason why the court should not. Before I hand over to my colleague, Mr. Karibara, to talk about the sureties, I want to seek the court's indulgence. I came a few minutes late because we came on a day flight. I'm also seeking to leave now because I'm on a flight to Nairobi at 4:30 because I have a funeral to attend tomorrow. So I seek the court's indulgence. I'll be leaving, but I'm comfortable that I'm leaving to a team that has performed so well and continues to explain all the facts to the court. Okay.
My Lord, mine is a simple task to introduce the sureties to the court. My Lord, in respect of the first applicant, we have lined up a total of 7 sureties. My Lord, 4 of those 7 sureties namely the Honorable Ibrahim
for each. What if you pick the best 4? You think they are substantial?
Yes.
The minimum of 4
So that's the debate I
for
was
each applicant.
It's the debate I was having with my colleagues here.
What is your view?
Because the first 4 that I was naming, my Lord, were sureties in application 113 2025. The first 4 that I was about to name were also sureties in the application 113 2025.
Yes,
Found
since I don't
substantial.
have that file here with me.
Yes.
This is a new application. I don't want to go in the chambers of another judge to look at the file. Why
Lord,
not
that's
proceed with your best possibility?
That's why I was going to seek your indulgence to see whether I should adopt or start the novel, but let me start.
Just get the form to see whether it's
My Lord, the first one is the Honorable Ibrahim Semujunganda. The Honorable,
we agreed that we get the first 4?
my Lord, I'll choose 4.
Yes.
Honorable Semuju is Honorable Semujunganda
The first
Ibrahim.
applicant now.
For the
Is that
first
first 4 for the first applicant?
Yes,
Or
ma'am.
4 for the second?
He is 52 years old, member of parliament, standing right here.
Yeah, you are already.
He's right here behind me. He's a member of parliament for Kira municipality. He's 52 years old. He's a resident of Weogerere,
Age?
52, my lord. Resident of Ukasa LC1, Weogerere Division, Kira municipality. He's a close friend of the first applicant. They both belong to the People's Front for Freedom. I have his original national ID, Parliament ID, and a letter of introduction from the
Do
LC.
you have them in photocopies?
The photocopies are also available.
Please, submit photocopies here. I will look at the written. Yes. If you have-
Plus the photocopy. Photocopy. Photocopy of IDs.
Is aged 52, Member of Parliament Harold Tony, aged 52. He's the Member of Parliament for Bukonzo County East, Kasese District. He's a resident of Katale Busaula LC1, Chengera Town Council Wakiso District. He is also a close friend of the first applicant and member of the same political party. I have his original IDs for Parliament, national ID, as well as photocopies.
I've looked at
The
them.
originals,
IDs
or the IDs.
I have looked at them.
But Mr. Bill, you have seen?
You saw this before.
Anyway, you see. My Lord, the third one is the Honorable Kamara Nicholas Thaddeus, standing at the back. Kamara Nicholas Thaddeus is the Member of Parliament for Kavale Municipality. Is aged 50 and a resident of Buye Chigowa LC1, Bukoto 2 Parish. Nakawa Division. He's also a close friend of the first applicant. And on the next, the fourth one is Mr. Philip Wafula Ogutu. And Lord, Mr. Ogutu is a resident of Village 14, Tinda Village 14 LC1, Salim Bay Road, Nakawa Division. friend and colleague for First Africa.
You can pass the edge. The edge is true.
My lord, he was born in 1952.
73 now. 73.
So, my lord, those are the sureties for the first applicant. For the second applicant, my lord, the first surety is Najita Halima Mutale. Halima Najita Mutale. She is 58 years old and a resident of Chisibula village cell, Mutundwe. She's the wife of the second applicant. That has her original ID and LC introduction letter. The next one, my lord, is Sewan Kambo Hamza, aged 48. Mr. Sewan Kambo is an advocate practicing with the firm of Sewan Kambo. He is 48. An advocate practicing with Sewan Kambo and Company Advocates. The brother of the second applicant is a resident of Kanava Cell, Deje Ward, Deje Division, Makindi Savagabo in Wakiso District. His original LC letter ID are also being shared. Hello, the next one is Zura Namfuka. Zura Namfuka is aged 27. She's aged 27 and the resident of Tiawa Zone LC1. Ukuli Konge Parish Makindi Division in the Kampala district. She's a daughter of the second applicant. Lord, the last one is Maria Mutale. Maria Mutale is an advocate of this court. She is 42 years old and a resident of Mengo Town LC1 in Namirembe Parish, Umaga Division. She's a daughter of the applicant. My Lord, each of those sureties has undertaken to ensure that the applicants attend court as each of the sureties has undertaken to ensure that the applicants return to court as and when needed. Each one of them has understood their duties as sureties. My Lord, they have sufficient ties with the applicants to be able to undertake their duties as sureties. It is therefore my humble prayer, my Lord, that they are all found to be substantial and, my Lord, in keeping in line with the ruling that I earlier referred to, miscellaneous application 113, 2015. My Lord, that is it.
For the record, Jatiko Thomas. Short stand of 30 minutes.
Or you can another state proceed.
They have been there for 3 hours.
We have
They have been there for 3 hours.
One can proceed if Jatiko wants to.
Yes, my lord. My lord, as respondents, we are working as a group, as a team. And there's some information, my lord, which was brought here when we are in court, for example, in respect to the sureties, for which as a team, not as a single prosecutor, we need to deliberate upon before we become prosecutor.
What?
The sureties and some
The sureties you reply later, but proceed from
My lord, the principle of here and that we seek a standard of 30 minutes to proceed, to be able to proceed. And it is our submission that we ask for 30 minutes to prepare and
It is my considered view and opinion that we proceed. There are 3 state attorneys in court. Let us proceed. Where you have reservation, point it out. In respect of the sureties. Where you have reservations. Let us proceed. Where there are some things we need clarifications, we shall reiterate.
my lord, we have an option to proceed. My lord, I will take the presentation for the respondent. My lord, this application is primarily the best objectivity that the applicants, before you, locked mandatory period before they are committed to High Court. And as such, they should be released. My lord, the applicants also raised other issues, other grounds like advanced age, sureties, among others. The respondent shall also make an omnibus response to the 2 applicants. This application is solely hinged on whether or not the applicants had brought mandatory and whether court can go ahead and admit them to bail. Premise on the way on the above the laws. Whether or not the applicants are developed mandatory, it is a submission the applicants had not blocked mandatory. In fact, by the time of filing this application, my lord, which is the 29th of May 2025, the applicants had already spent 98 days on remand. 98 days on remand. Yes, my lord. My lord, we refer you to paragraph 15 of the affidavit of Detective I.Q. Kizza Besigye in respect to the first applicant, and paragraph 12 of Detective Inspector of Police Kizza Besigye in respect to the second applicant. My lord, the applicants were remanded in custody on the 21st of February 2025. And that was the time when the Office of the Director of Public Prosecutions had taken over or had instituted fresh investigations and therefore brought fresh charges against the applicants. My lord, the applicants were charged with on the 21st of February 2025, they were charged with treason and misprision of treason. My lord, it is not true. It is not true, therefore, that the DPP was in charge of this matter, of the applicant's matter, while they appeared before the General Court Martial on the 20th of November 2024.